afternoon. I think we can start off. My name is Liesl van der Westhuizen. I'm a client relationship manager from Kaelo, and alongside me today is Celeste Willifeer-Blau, who is our head of Ask Nelson, which is the Kaelo EAP solution. And it is my privilege to welcome you all to the February webinar. As we all know, February is the month of love, and all over the world, we celebrate, relationships are celebrated. But as anyone who has ever been in a relationship with another human being knows, relationships are tough. I think when we fall in love for the very first time, everything seems bright and beautiful, but as time goes on, it does become more difficult.
Liesl, yes, you're 100% relationships are not easy. I think we see this in our Kaelo lifestyle program when majority or quite a large number of our people who engage in counseling support services are engaging around relationship support. We also see this in the legal service offering, is that family law is one of the areas that's highly utilized.
Celeste, from your experience, what happens when relationships comes to an end?
Sure, Lee. So I think the reality is that we know relationships start out great, but they do come to an end. We see that in statistics. So 2021 statistics show that around 4 out of 10 marriages would end in divorce before the marriage hits the 10-year mark. And in 2021, 18,208 divorces were granted, and there were 17,345 children under the age of 18 affected by those divorces. I think what we see when people enter the Ask Nelson program is they often come with a lot of ideas. So well-meaning advice from family and friends that's not really linked to what should be happening from a legal perspective. One of my favorites is where someone would say, I'm not letting my husband or ex-husband see the children because he's not paying maintenance. And from a legal perspective, that's not accurate. And that's why we have the lovely Stella and Mervyn with us today, because they're going to share what should be happening when relationships comes to an end.
Absolutely. Understanding our rights and responsibilities when it comes to family law matters is so important. And therefore, I'm very excited to introduce Mervyn Vermeulen, an expert in civil litigation and family law, along with Stella Coetzee, a family law mediator, who will be sharing some light into navigating the rights and responsibilities when it comes to family law matters. Mervyn, warm welcome, and thank you so much for your time this afternoon. And perhaps a simple question with a complex answer. But Mervyn, if someone has reached the end of their relationship, what happens from a family law perspective?
Thank you so much, Liesl and Celeste, for having us today. I really appreciate this opportunity to chat with you and with everyone who is joining us online today. I appreciate the question, and I'll jump in with it. Just as an aside, before I jump in with it, to the attendees, you'll see on your screen there is a lovely chat bar where you are welcome to put questions to myself and to Stella that will really assist us to give you the information that you would like to get out of the webinar today. So I suppose, Liesl, to answer your question, one has to start with a sub-question, and that really relates to whether the relationship that comes to an end is a marriage relationship or not considered a marriage relationship. Now, in South Africa, we have various types of marriage relationships. It could be a civil marriage, it could be a civil union, it could be a customary marriage, and as of quite recently, following a constitutional court decision, a Muslim marriage also now is seen as a marriage that's capable of being dissolved by a divorce. If one is not in a marriage, if you are simply in a cohabitation relationship, or if you have especially, I suppose, if there are children involved in the relationship, whether you're married or not, it's not as simple as simply cutting ties in terms of the relationship. There are certain formalities that one needs to deal with, and that's where Stella and I will be really focusing much of our discussion for today's purposes. I'll obviously be looking from the legal side, and then Stella will be looking from the perspective of a divorce mediator or a family mediator, not just divorce, but also in respect of unmarried persons. To start off, I think let's look at divorce specifically, since that's really the tenor of the introduction that you guys did, and I thank you for that. In South Africa, divorces still need to be granted by a court. Whether you are agreed with your spouse regarding the terms of the divorce, or whether you're not agreed, the matter has to run its course through the justice system or the judicial system in South Africa. If it is an unopposed matter, in other words, if the parties have reached agreement on all the terms, it becomes more of an administrative exercise running a few weeks, whereas if parties are not agreed on the terms of the divorce, it can be certainly a very long process indeed. At the end of the day, what one essentially wants is a decree of divorce that can only be granted by a court in one of two ways. As I mentioned earlier, either by agreement between the parties, which would be in a settlement agreement, or a consent paper, as they call it in the Cape, or it would be in terms of essentially a decree where the court would decide and act as arbiter between the parties on what is fair and what is reasonable. These disputes can take up to 5, 6, 7, 9 years if one is really involved in a very, very bitter fight. And that's where someone like Stella comes in. And I think a lot of the discussion that I would like to enter into today from an attorney's perspective is the benefits of mediation and the benefits of settling matters before approaching the court. So Stella, I suppose, let me hand over to you, and if you can please tell us a little bit about what mediation is, how it works, and what to look out for.
Thank you, Mervyn. And first of all, very welcome to all our attendees, and thank you very much to Liesl and Celeste for affording us this opportunity. So yes, Mervyn, so first I just want to say up front, people sometimes get confused with mediation and counseling. Mediation is not counseling. It's not to save the marriage. So by the time that couples come to mediation, they've already exhausted all. Well, I normally ask my clients, have you exhausted all avenues to try and save the marriage? If that has all been done and they decide, no, there is no way, they want to part ways, then mediation is the better option, especially when children are involved. So let's just quickly look at what is the basic core principles of mediation. Firstly, it's a confidential process where the process is without prejudice. So in other words, parties can't use the mediation process to fish for information about the other party's affairs and maybe try and use it later on in litigation. What happens in mediation stays in mediation. So if the mediation does not succeed in terms of finding a settlement within mediation, what was discussed in mediation cannot be taken to court at a later stage. Also very important, the mediator is an impartial person. So the mediator is not there to judge any party. It is really there to listen to both parties and to find out what is the interest of both parties, what is most important for them to come to a solution for their divorce. Just another thing, mediation is a voluntary process. So at any stage, if one of the parties or even the mediator, if they feel that this process of mediation is not working, either party or the mediator can discontinue and stop the mediation. Another important dimension of mediation is that it addresses both the emotional and the legal side of a divorce. So we don't just look at, like in the case of when you go for litigation, the focus is more on the legal side, which is not taking in consideration the emotional side as one would do within mediation. And then, of course, mediation is a very cost-effective process. We all know time is money, and the mediation process is much quicker than a litigation process. Another big benefit of mediation is that the parties can control the outcome of their divorce, whereas with litigation, the magistrate or the judge, they decide at the end how the final divorce decree is going to look like. Yeah, so Mervyn, from your side, I think if we can maybe talk some about case law where there was specific case law around where the courts and maybe just talk about the rules that came out around mediation, that it's still a voluntary process, but the courts are really enforcing people to consider mediation. So if you want to delve into that, Merv?
Absolutely. Thanks, Stella. And I'm seeing the questions are coming through thick and fast, and I absolutely love it. I see you've got a few people with their hands up as well. I'm going to answer as much as I can in the comments, guys, but we are working at a fairly brisk pace. So what you are welcome to do, as Celeste has indicated in the chat, she will be sharing our details. So you are welcome to email us directly as well for a little bit of information. So the rules that Stella was referring to, folks, is the Rule 41 capital A of the Uniform Rules of Court, which essentially says that parties need to consider mediation as an appropriate resolution tactic before going into litigation, and that applies essentially for every single new divorce case that is opened up in the high courts, at least throughout the Republic. The rule is still quite new, so we are still waiting to see exactly what the courts are going to do with it. It is, at this stage in South Africa, it's mandatory for parties to consider whether they are willing to mediate and to file a notice to say whether they are going to mediate or not. It is not yet in a position where a judge will say, or a magistrate will say, go out, mediate, go settle, come back to me. The reason for that is because in terms of our constitution, everyone has the right to equality before the law. And if one gets to a position where courts are saying you must go mediate before you can litigate, there is an argument to be made that you're closing the doors of justice on litigants. There's a very interesting movement now in the UK, and they're a couple of years ahead of us in terms of this discourse on mandatory mediation or not. And there was a very interesting judgment from the UK family courts about 2 or 3 months back, where the court essentially said, the court can order mediation provided there are certain safeguards. So, for example, issues where there's an element of domestic violence and that sort of thing, the court is not going to be inclined to order mediation. Traditionally, we know that in terms of family courts, a lot of what we get from sources such as the United Kingdom. So hopefully that discourse is going to come to South Africa soon. What I can tell you from the perspective of an attorney is it is certainly very, very important to consider mediation before you go into litigation. We've got a question here, and I'm going to refer to the people asking the questions just by their first name, so that you at least know who I'm referring to, but we don't blast your personal details all over the internet. And a very interesting question on the topic of mediation, specifically from Natasha. If I understand correctly, you don't have to go the litigation route, but opt for mediation as a resolution. This means we don't then have to go the litigation route and save the massive amount of money spent on litigation. That's absolutely spot on. But there is a proviso to that, Natasha, and it is this: it takes two to tango. You cannot force a person to mediate. So if you approach your spouse and you say, let's go the mediation route, and they are unwilling to do so, the path is unfortunately laid out for you that you would have to go through the litigation process. However, and I think that here I'll pass the ball back to Stella. I see there are a lot of questions for me to bash on my keyboard in the comments, which I'm going to try my best to do. But mediators have specific training in terms of how to bring people to the negotiation table. And perhaps I can hand over to Stella to just talk a little bit about that. But certainly mediation cannot be thrust upon or forced upon anyone at this stage in South Africa.
Yes, absolutely right, Mervyn. No one can be forced. As I said, it's a voluntary process, so no one can be forced. However, it is always in the best interest of the parties, especially where children are involved. And one would, if there is one party that is maybe not prone to mediation, once you speak to the person and explain all the benefits of mediation, it almost becomes a no-brainer to actually do the mediation, especially around children. In practice, I've seen cases where people has tried litigation for 2 years or longer. They spent hundreds of thousands of rands on litigation, and then they come for mediation, especially now recently with the court rules that came out. One finds a lot of attorneys actually advise their clients to go for mediation. And those divorces, and again, as Mervyn alerted earlier on, it's not just divorces. It can be where a couple they did not get married, they start building a life together, they've got a house together, they now have children together, and then later on they decide to part ways. In such an instance, mediation is ideal to work through a parenting plan for the children and to work out the maintenance that's relevant to the children. Because at the end of the day, as per the Children's Act, if both parents are no longer staying together, there needs to be a parenting plan in place which stipulates, how and when are the children going to have access to both parents, what is the responsibilities of both parents in looking after the emotional, the financial and physical health and well-being of the child. So just to come back also, and Mervyn might correct me if I'm wrong, the court will not grant a divorce if there is not a proper parenting plan drawn up for the children that's been signed off by the family advocate. The process, I know here in the Joburg area, is once the summons has been issued, the parenting plan still needs to be endorsed by the family advocate before the court will issue a court date. And mediation is really the best way to come to an agreement on how the children will be looked after. So Mervyn, back to you. I hope I answered your question.
Yeah, absolutely. Stella, and just as an aside, I would not dare correct you if you're wrong. I know how hardcore you mediators can be. So you are spot on, though, in what you're saying. And I think this is something that really is important and should be the first consideration for anyone going through a split, is that in terms of Section 6 of our Divorce Act, which is the legislation that really governs divorce in South Africa, a court won't grant a divorce unless it's satisfied that there are sufficient provisions made with regard to welfare of any minor or dependent child of the marriage. And then you need your family advocate's endorsement to say that this is, or whatever is agreed upon, is in the child's best interest or the children's best interests. So as far as that's concerned, yes, parenting plans are very, very sensible. I had a private question from someone saying that the father is going on a trip and should they get something in writing? And absolutely, one should, as a first port of call, try to establish what the arrangements are going to be in terms of children. Now, folks, you'll know older children is it's quite easy, the concept of older children, or when there are older children. And to illustrate that, I mean, try and tell a 15-year-old, you will do this weekend. It's the quickest you're going to get someone to do the exact opposite. I always say, when a child is 15, you want to tell them to go and get a job now and take over the world now whilst they still know everything. So the arrangements are often very loose because these children have very strong voices and they can articulate their voices. But when you're sitting with very little ones from birth up to preschool and those formative years, you are faced with two potential problems that need to be canvassed very, very carefully. The first is, number one, the position is going to change day on day, never mind month on month, not only financially, but also developmentally. My wife and I always have this kind of seesaw that we do with our child, where one day it's all about mom, the next day it's all about dad. And today they love this, and the other day they love something completely different. So the position changes, number one. Number two, these children are not always able to articulate, at least verbally, what their views and their wishes are. So one must be very, very careful in formulating this. Now, parental responsibilities and rights. Now, for those who haven't heard these terms before, parental responsibilities and rights is what we used to call the old custody and access, which have kind of fallen into disuse. They're not really very trendy words anymore at all. And that really comes down to four aspects: contact, care, guardianship, and maintenance. And all of these have a part that they play in defining what the role is of a parent in the life of a child. That is the first thing that you need to look at in terms of any split, not only divorce necessarily. And as Stella and I have unpacked already, that can be canvassed in a couple of ways. And I think by way of summary, the first and the easiest and the most informal way is to have a discussion between the parties. Not necessarily a mediated discussion, not necessarily a discussion with a lawyer, but a discussion. This is what I am thinking of. How are we going to handle it? The caveat there, folks, is if you are in a relationship where there is a high power imbalance between the parties, one party is the complete breadwinner, the other party does not have any income earning capacity, or there are elements of abuse, be it mental, verbal, physical, etc., that's not always the best idea, because you may, one of the parties may be open to victimization. The second option is to go into a mediation process and have a mediator assist the parties to communicate. And then the third option is to lawyer up. Now, when is it a good idea to lawyer up as opposed to the other two options? And it's really two scenarios. Number one, if you are uncertain about what your legal responsibilities and rights are, it is a good idea to see a lawyer. And make sure that you see a lawyer who gets it, who is not necessarily going to say, let's go and litigate, because no one wants to go into litigation unless they really have to. It's like going to a surgeon who says, I'll see you in theater tomorrow. Unless there's compelling reasons, stay away from that. Try and deal with it more conservatively. The second reason to go and see a lawyer at an early stage would be if you do foresee that there is an insurmountable hurdle. For example, one person says the antenuptial contract says this, the other person says, no, that's not what it says this. And you cannot come to an agreement, and it's something that the court will have to look at. That being said, mediators are also trained in this stuff. So very often your mediator can, from a very neutral perspective, tell you a little bit about what your responsibilities and rights are without actually advising you. The mediators have a beautiful saying that you're allowed to inform, you're not allowed to advise. And apologies, guys, I just got 3 spam calls in a row in the middle of the webinar. If any of us think that this spam calling is getting out of line completely. Before we go into proprietary aspects and maintenance, Stella, if I can ask you to maybe just elaborate on the whole idea of, if you're uncertain about your rights, what role could the mediator play? What can and can't the mediator do in terms of informing you about your rights? And then I suppose let's jump into the property stuff, which I'm sure everyone is dying to hear about, and then maintenance as well. Sure, we're going at a brisk pace, eh?
Absolutely. Time flies when you're having fun, hey? Yes, Mervyn. So the mediator, as you rightfully say, as a mediator, we're not attorneys. So we are not giving legal advice. We can, however, give legal information. What is important is to go back to basics in terms of the Children's Act. What is in the best interest of the children? First and foremost, the children has got a right of access to both parents. It's not just one parent that's important. It's been proven that children needs both parents. And the Children's Act also reiterated that both parents the children has got a right to both parents. On the other hand, the parents both of them has got responsibilities in terms of looking at the emotional, physical, as you said, care contact of the children. So I want to bring in here Melissa's Fouris question on about the responsibilities of a father when he decides to work overseas for 9 months at a time. Just to clarify, the parents of the child are not married. Should there perhaps be a written agreement between the parents confirming the father's undertaking that he would continue to provide financial support? That's a very good question, Melissa, and that speaks to the Children's Act in terms of a parenting plan. So ideally, a parenting plan should be drawn up for this specific this family in terms of when and how is the father going to have access to the children, but also as you asking about the financial support with a parenting plan. It's not just about the care and contact, it's also about the financial implications. So one would do a maintenance calculation of according to the income and expenditure of the income of both parents, as well as the expenditure of both parents and specific expenses relating to the child or the children. A calculation is then done to determine what the maintenance should be, and that is written into the parenting plan. So in this instance, where they were not married, the actual parenting plan combined with the stipulated maintenance that gets written into the parenting plan then becomes a court order. It goes to the family advocate, and from there it goes to children's court, and it becomes a court order. So both parents have got recourse should one of the parties not adhere to the terms and conditions. I just want to, something else that comes to mind, Mervyn, is we talk about minor children, but we know, especially now in South Africa, as soon as a child becomes 18, they're no longer considered a minor child as per the Children's Act. However, parents are still responsible to financially support the child, even though they are over 18, if they're not self-supporting. And we find a lot, it happens that as soon as a child turns 18, and the child could maybe be still in matric, not even finishing school, and dad decides, no, it's 18, I'm not obliged to pay maintenance anymore, and that is really a no. You cannot, that's some advice also, not legal advice, legal information. Don't just stop paying maintenance. You need to go to court and apply for an adjustment to the maintenance. So maybe, Mervyn, you can talk a bit more on the rights of children over 18 that's still not self-supporting.
Absolutely, Stella. I suppose let's go into the realm of maintenance, and if there is something that there is that is contentious and where very bitter battles are fought, it's really in the maintenance court. Now, before we go into major dependent children, I think it's a very good point that you raised there, Stella. We need to look at what the position is with regards to minor children. Parents have to support their minor children. Why? Because the Children's Act says so. Section 18, we have legislation from Parliament that says under parental responsibilities and rights, it is an obligation on parents to maintain their minor children. Then we went through a very interesting development in our law. We don't have any legislation that deals with major dependent children. Now, what is a major dependent child, folks? A major dependent child is a child over 18, but who hasn't essentially been kicked out of the nest completely. So we're talking about children who are, for example, at varsity, or children who are doing a gap year, or whatever the case may be. They are over 18, they are majors, they have full legal capacity in the eyes of the law, but they cannot pay their own rent yet. What is the position there? Now, this went through our courts insofar as there's no real legislation that deals with these children. And over a couple of years, there was a lot of development in various cases, which I won't bore you with the details, but that came to a culmination of in a matter of Z versus Z, which was in the Supreme Court of Appeal, where the court essentially said, absolutely, if you get divorced and you are a parent of a major dependent child, you can absolutely claim maintenance for your major dependent child in the divorce court. There was a subsequent decision in the Cape Division, in one of the circuit courts there, where the judge said essentially that extends to maintenance court as well, where you can seek maintenance for a major dependent child. Now, maintenance, apart from knowing that you have to maintain a minor child and a major dependent child, is a factual question, and how you determine this factual question differs from case to case. And this is incidentally one that I definitely will be throwing back to Stella, because this is a big part of what I know she does is these calculations in terms of who pays for what. You'll very often hear some people say 1/3, 2/3, 50-50. It is a factual question. There are these rules of thumb, which sometimes is used in the courts, are used by lawyers or mediators to say, you buy one set of groceries from Pick and Pay. How do you split? This is for me, this is for the child. And then there are ways of apportioning it. But it is essentially a factual question. And Stella, I'd like to hand over to you just to talk a little bit more about that.
Yes, thank you, Mervyn. I love the maintenance side of mediation. Okay, so the starting point for determining maintenance for minor children or even older children, children that's over 18, is we would typically first look at the income of both parents. So if mom earns 10,000 Rand, her net income is 10,000 and dad earns 20,000, dad's contribution to the children will be twice as much as mom's. So it's really in proportion to the income of both parents. So that's the first thing. Secondly, we then look at the expenses at the two homes, at mom's home and at dad's home. What are the expenses specifically relating to the children? Directly relating to the children would be like your school fees, school clothing, books, extramurals, etc. Then you go and look at the other general expenses at each home, and we look at bond repayments or the rental, rates and taxes, water and electricity, maintenance on the cars, so the list goes on. If everything that you pay on a monthly basis, we then allocate a certain portion of those expenses to the children as the children's expenses. So the way that allocation works is to go and look how, first of all, how many days in a month does the children stay at one house? Is it primary residence where the children maybe only sees dad every second weekend? So the time that is spent with mom is much more than the actual sleepover time with dad. So the weight that one then allocates to the expenses of at mom's place to the children would then weigh much more than on dad's side. So that's a way to look at the expenses. And then also, as a good mediator will go through the expenses and then look at the affordability. We find often that people really live beyond their means, and you do this beautiful calculation, but then there's one very big shortfall at the end of the month. And then what we can do in mediation is then to look at the expenses. Where can we maybe cut some costs, help the both parties to re-look at their expenses and really to at the end of the day that the income statement can balance back so that there's no shortfall. So just another thing, I saw something about spousal maintenance, also a very interesting subject. But I'm going to go over to Mervyn again on spousal maintenance. What does the law say about spousal maintenance, Merv?
Thank you so much, Stella. Sure, and we've had some interesting questions in the chat bar. Thank you so much, guys. Please do keep them coming. I'm trying to get to as many as I possibly can. For the very, very complex ones, I've asked some folks just to email me because we need quite a bit of detail just to have a look at it. So, guys, please don't be shy. pop your questions in the chat bar and we'll deal with it. Spousal maintenance, very, very interesting question, Stella. Now, in terms of South African common law, and it comes from the old Roman Dutch law, parties who are married have what's known as a reciprocal duty of support to one another. So in sickness and in health and in richness and in poverty and all wealth and poverty and all of these lovely concepts, what does it mean? It means that if I have money and my spouse does not, I need to support them. If they have money and I do not, they need to support me. Or if one lives in South Africa in 2024, neither has money and we all have big problems. But I'm just joking. So in terms of the issue of spousal maintenance during the marriage, it's a very simple common law. You have to support one another as spouses. That, however, comes to an end when you divorce. The minute you are divorced, you no longer have this reciprocal duty of support. There is a clean break. And for that, the Divorce Act had made provision in Section 7.2 of the Act that an order can be made for the one party to pay spousal maintenance to the other party post-divorce. Now, this can be a couple of things. It could be cash payments, contributions in kind, payment of medical aid, for example. There are various forms that this maintenance can take. Furthermore, this maintenance can be rehabilitative in nature for a couple of months, a year or two to get the spouse back on their feet, or it can be lifelong. So there are various ways that spousal maintenance can be determined or can be adjudicated upon, or the final outcome can be, but it essentially comes down to a whole laundry list of factors that's contained in Section 7.2 of the Divorce Act. It looks at the means of the parties, the age of the parties, what are their needs. It looks at the standard of living prior to the divorce. It looks at misconduct by the party during the marriage, and it even gives a catch-all of saying any other factor the court deems just. So it is very broad, very fact-dependent, but the court can then make essentially this order that one party has to maintain the other party financially. Now, this can be done by agreement, folks, or it can be done by a court deciding what is fair in terms of spousal maintenance. Is a spouse entitled to it? If not, why not? And if they are entitled, what form should it take, and what should the quantum or the amount thereof be? What is the overriding factor really when it comes to spousal maintenance is you have to have a bona fide need. Don't claim spousal maintenance if you have a few million rand stashed in your bank account, because then you don't necessarily have a bona fide need for spousal maintenance. It is there to assist a spouse who does not have the means to support themselves after divorce to either have spousal maintenance for life or to have a interim kind of maintenance in terms of getting rehabilitated. Now, here's an interesting one, and one that, funnily enough, sometimes is mediated. Marisha asks, how long can a parent default before you can go to court you have the right to? So now I'm assuming that there is a court order in place. Now, there are two ways that you can go to court. You can go either in terms of getting a warrant issued against their movable assets or their pension fund to say, you owe me X amount of rands, go to the maintenance court, do an affidavit and get paid. Or you can do contempt of court proceedings, which essentially you can have the person locked up. So use that one very, very judiciously. It depends on the facts of each matter. Technically, one can go immediately if there are arrears, but in practice, one would usually have a lawyer send a couple of letters of demand and really try to engage before going to court, because one wants to stay out of court. As I mentioned, the comparison between going to surgery or going to court, it is best avoided. However, what happens sometimes is that the default is not in bad faith. the party defaulting might have a real problem. Lost their business, lost their job. COVID was a big one that really led to a lot of fights in terms of maintenance. And in these cases, very often, strangely enough, these things go to mediation. And mediators, lovely pronunciation there, Stella, sorry about that. Mediators can often help parties to actually get some sort of conclusion and say, well, this amount is owing. How are we going to deal with it? Stella, would you like to elaborate on that?
Yes, absolutely, Mervyn. So up to now, we've really talked about in the process of a divorce or separation between two unmarried couples, or the parenting plan maintenance around that. But what one needs to remember is any time, and mostly I write it in all my parenting plan, that the parenting plan will be reviewed as and when circumstances changes, either with the children or with one of the parents. So as Mervyn said, anything happens, one of the parties might have lost their job or whatever the case might be, and there is a need to change the maintenance amount, whether it's up or down. Then mediation is the best way to actually come to the table. We relook at both parties' income streams, all the expenses relating to the children, and we can renegotiate a new amount for the parents for maintenance. And then once the parents have agreed on that, then that's very easy then to go to maintenance court and have the new maintenance amount made a court order. And the same goes for after the divorce, things change. We see a lot of immigration of maybe one of the parties going overseas, and the other party maybe staying behind in South Africa. What then happens with the children? So that's also a perfect example of where one can adjust the parenting plan. Well, it needs to be adjusted because, there's a lot of changes happening in terms of care and contact and also financial implications for the children. So yes, that is, I saw something else here. Yeah, I think, so just to come back to, any changes after the divorce. So what was decided in mediation or in litigation, the final outcome of the divorce relating to the children parenting plan, that all can be adjusted, as and when there's changes either way in the children's lives or the parents. I just want to also quickly touch, I see our time is running out, just on the emotional effect of high conflict between parents and the effect that it has on the children. There's been widely academic studies that has proven that there's an emotional, a social impact as well as a psychological impact on children's development if the children are exposed to high volumes of acrimonious relationship or high conflict between the parents. For instance, children can lead to feelings of anxiety, fear, insecurity. That's on the emotional impact on children. Children may experience heightened stress levels, have difficulty regulating their emotions, and exhibit signs of depression. And also what we see is the children can develop internalizing or externalizing behavior. For instance, they can show aggression or withdrawal. And we see that in litigation. You can imagine if mom and dad is in this litigated trial court and it's going on for years and years, obviously parents are stressed, and that then filters down to the children. And that is one of the big reasons, apart from the money and it's saving time, the emotional impact that long drawn out acrimonious litigation have on the children. So maybe we can look at some more questions.
I would like to touch one thing, if you don't mind, Stella. And I see we've got about 7 minutes left before Celeste and Liesl release us back into the wild, and that's just the issue of proprietary consequences. Now, guys, we've spent a lot of time talking about kids, and we've spent quite a lot of time talking about maintenance as well. But also understand, if there is divorce, one of the biggest concerns that you need to speak about with your spouse up front, before the divorce is finalized, is how are you going to deal with the property, with the assets and liabilities, essentially, in terms of the marriage. To do that, make sure that you know what your matrimonial property regime is. If you are contemplating a split, whether or not you've engaged with your spouse yet, make sure that you know, are you married in community of property? Are you married out of community of property with the accrual? Are you married out of community of property without the accrual? What does this mean? And what are the potential legal remedies that are available to you? It's very important to note, guys, there is huge change happening in our law at the moment in terms of remedies that are available at divorce in terms of property, especially with regards to marriages out of community of property without the accrual. There is a new remedy available, an old remedy that's again become a new remedy for a spouse who's married out of community of property without the accrual to claim a transfer of certain assets if they made a contribution to those assets, etc. So please make sure that you also upskill yourself, or you just get yourself educated in terms of what are your proprietary rights if you are considering, and we unfortunately don't have too much time to spend on that, but I think I would have felt remiss not at least touching on that. So the real 4 big issues that we look at when it comes to divorce is kids, number one, and I deal separately with maintenance for kids because it's almost a standalone issue, even though it falls under the umbrella of kids. Then we look at spousal maintenance, and then proprietary consequences. Then I see one of the questions: can a father object to a minor child's surname being changed to both parents' surnames after divorce? Yes, they certainly could. It falls under parental responsibilities and rights, and that is in respect of Section 18. Is there somewhere we can refer to see what changes there are in law for marriage outside of community of property without the accrual? I wrote an article on this a little while back, Michelle. I'll share the link with you shortly, and if you would like to go and have a look at it, it is a constitutional court judgment of G versus Minister of, I think it's Minister of Justice, I think, but or Minister of Home Affairs, apologies, G versus Minister of Home Affairs. And the remedy especially that one is looking at is in terms of Section 7.3 of the Divorce Act, if you would like to go and have a look at that. So long. So I suppose we've got 4 minutes left, and I'm going to shush now to allow Stella to kind of tie a ribbon around the webinar for us, and then obviously handing back to Celeste and Liesl. I want to pose a question to you, Stella, just because I think it's an important one for the attendees. What is the biggest mistake people made when considering a divorce?
What is the biggest mistake? I think the biggest mistake is to actually, inevitably, most of the time, one of the parties are very aggrieved by the actions or the reason of the divorce. And the biggest mistake I think people can do is to use the children as pawns to get what you want out of the divorce. By, a simple example, if you do this, then you can see the children, or, that type of thing. And not to take the children's best interest at heart when decisions are made. I quickly want to, there's an extract from a book, Children and Divorce, Parenting Tips Parenting Tips to Help Your Family Cope and Adjust by Sharon Ray. I just want to quickly read that to you. Every parent worries about their children during divorce, but what they don't think about is how their child will fare emotionally later in life. Now, as a 45-year-old adult, married with children, my parents' divorce still affects me. Holidays are the most stressful time. Which side should I invite over? Whose house should I go to? Will I hurt someone's feelings? It's still a tug of war. Yeah, so I think the biggest mistake is to have a tug of war over the children. So that's the end from my side. Thank you so much again to Liesl and Celeste. It was, I can't believe an hour is gone, but thank you.
Brilliant. Stella, Mervyn, heartfelt thank you for the privilege of your time this afternoon. And I found this webinar quite insightful myself, and my heart's desire is that everybody on this call found it insightful. Just a reminder for those individuals who have access to our Ask Nelson program that provides free counseling, we can also put you in touch with the mediator. So if you do need support, or you know of someone, a dependent or a loved one who needs support, please do reach out. This webinar will be, it's recorded, and the recording will be made available on the Kaelo website, together with Stella, information on Stella and Mervyn. So if you do want to reach out to them directly, you can locate their details on the Kaelo website as well. Thank you so much for your time. May you have a lovely day and take care.
Thank you all.
Thank you.
Thank you so much for having us, everyone. Enjoy the rest of your day, and I think may I go back into the wilderness from here now.
Enjoy, Mervyn.
Great.
Thank you,
Thank you so
guys.
much, guys. Thank you, everybody.